Good afternoon. Welcome to the Nebraska Court Improvement Project 2020 Legislative Review. I'm Deb Van Dyke Reese, and I'm the director of the Nebraska Court Improvement Project, and I want to welcome you to today's webinar. This webinar is being recorded and will be uploaded to the CIP YouTube channel in the next couple of weeks if you would like to review it. I'm going to take a few minutes to introduce the panel for today. And I have Jeannie Bradner, Judge Larry Gendler, Juliet Summers, Sarah Helvey, Marianne Harvey, Mary Pat Coe, and Steve Green. They all will be discussing different bills that were passed this legislative session, in addition to some legislative resolutions that will be discussed. To start our webinar off, I'd like to just give an overview of what the Court Improvement Project is. For those of you who are not aware, we are part of the judicial branch, both the Administrative Office of Courts and Probation. One of our key projects is the Through the Eyes of the Child teams, which are multidisciplinary judge-led teams that cover every county in our state. Really, the focus of those teams is to look at the court process, the juvenile court process, and identify issues, and then also solutions to those issues on a local level. Another key piece of what we do is education. So webinars such as this, or our Children's Summit, or our regional conferences are a key piece of what we do, a service that we provide to the juvenile court stakeholders across the state. I did want to point out a couple of things. We have another webinar coming up later this month that is going to be focused on Medicaid expansion, and that will be on September 22nd. And then we do have our annual CIP conference that is held on September 28th, where we are partnering with an organization called Strategies for Youth to look at the school, law enforcement, court connections. So hopefully you can join us at either of those sessions. All of that information can be found on the Court Improvement Project website. So registration information can be found there. So I will go ahead and introduce our first presenter, which is Judge Larry Gendler, who is with the Sarpy County Separate Juvenile Court. Thank you.
All right, thank you. Good afternoon, everybody. I'll try and be brief so we have enough time for questions. I've been assigned just a few things here. The first thing I want to discuss is LB 93. That was Senator Wayne's bill. It was a holdover bill from last year, and it was modified a little bit for this year, but it allows for a parent, a father, or somebody who thinks they're the father, to essentially petition a juvenile court to request a DNA test to confirm whether or not they are a father. It's located within the paternity statute. So ostensibly, I guess the idea here is that the juvenile court can entertain a paternity action in this regard. The process isn't laid out as clearly as I would like, but it does provide for that opportunity for a father. And the costs of the testing are to be paid by the intervener, the county, or the state. And that's really at the discretion of the juvenile court. I think most courts allow for something like this now in terms of determining whether or not somebody is the father, but this essentially codifies that practice. We have a couple of resolutions. I know Jeannie's going to jump in and talk about one of these. LB 393 is going to be a study of status offenses in Nebraska, and this has come up several times, whether or not we should try some sort of alternative approach to all the status offenses, some of the status offenses, and most notably school truancy. So my guess is there'll be some sort of legislative hearing set in the fall to discuss that. And Jeannie, is there anything else you wanted to add to that?
Yes, Judge, thank you very much. I just wanted to add as well for Legislative Resolution 393 is that the branch has been working very closely with Senator Pansy Brooks' office in the introduction of this bill, as well as some work that is transpiring on the Probation Services Committee related to status offense populations. We have piloted a way of responding differently to youth in Lancaster County, and we're looking at some potential statewide reform for those youth that are court involved at this point in time while the statute does require that. So that's what I wanted to add. Thank you, Judge.
Okay. I also wanted to talk briefly about LB 419. And this is going to be a study with regard to requirements for state services, consents, and that sort of thing with youngsters. And I just want to point out that we, under 4809, really 4801 et sec, there is a procedure set out for emancipation in Nebraska. So this is just going to be something to study that just a little bit further. And I'm guessing there'll be a legislative, that's 419. I'm sorry if I may have given you a different number. So that will probably be studied sometime here over the fall as well. And then I think I had on my list, maybe I have the wrong number here, that at 409, which is dealing with drug testing protocols in the child welfare system, and whether or not we should try something or look at how the department manages and implements those court orders regarding random drug tests, or even on those voluntary cases. I lost my list, and I can't recall if I've got everything or not. I'm assuming I did. Let me just take a look here. Yeah, I think I've pretty much covered my list. Sorry about that. I just noticed it was on the screen. And if others have questions that we don't get to today, just please feel free to email me at lgendler@sarpy.com. And that's pretty brief, but I just wanted to leave time for questions for others and presentations by others. So thank you.
Okay, and we'll turn it over to Juliet now.
Thanks all, and thanks for having me. I'm Juliet Summers. I'm the outgoing policy coordinator at Voices for Children in Nebraska. I'm really happy to be here with you today. I'm going to talk about YRTC, Youth Rehabilitation and Treatment Center specific legislation. So if you can remember, way back in January, there were, I think, 16 pieces of legislation introduced relating to the YRTCs and what should happen with them. Many of those, a number of those were introduced by the Health and Human Services Committee collectively, and then there were quite a few by individual senators. So of that crop of 16 bills, really there were 4 packages that came together. So I'm going to talk to you about those packages and kind of where they stand, where we stand in terms of future planning with the YRTCs based on that. So the first package, major package of YRTC related legislation is LB 1140, which also now includes LB 1141, 42, 43, and 45. And essentially this is a defining and authorizing and planning package. So it defines in statute and sort of creates authorizing language for the Department of Health and Human Services to operate youth rehabilitation and treatment centers, and sets out some baseline requirements of what those need to provide. So I'll give you some examples. Training specific to the population served, an evaluation process to develop an individualized treatment plan, age appropriate and developmentally appropriate education, etc. The provisions from LB 1141 require a 5-year operations plan be developed with stakeholder input. And that has to include an organizational chart with designated clinicians and administrators for each facility, descriptions of the rehabilitative programs and mental health treatment offered at each facility, a plan to segregate youth by gender on separate campuses, a statement of rights for youth, quality and outcome measures for tracking outcomes after discharge, and that includes an exit survey of youth, trauma-informed training for staff, and a grievance process for youth, as well as others. And this plan, this 5-year plan, has to be submitted to the legislature by December of 2021, and then updated annually thereafter. There was an amendment adopted on select file to this package that requires the agency to hold off on establishing any new YRTC or moving a YRTC to a new or existing facility, at least until the completion of this planning process, which this amendment has as no sooner than March 30th of 2021. The idea being that the legislature coming back next year can have some input into the strategic planning process, and then also, what's authorized moving forward. There is included in this package LB 1143 that requires emergency plans in the case of natural disasters, et cetera, and also a provision from 1145 that doesn't require, but authorizes a needs assessment and cost analysis for establishing an inpatient adolescent psych unit at Lincoln Regional Center. So that's LB 1140. LB 1144 is kind of the oversight package. So it creates additional reporting requirements from OJS to the Office of the Inspector General for Child Welfare. They have to report any critical incidents as soon as reasonably possible to the IG. And there's a list of what that at the base or baseline includes, such as assaults, escapes, attempted self-harm or attempted suicides by youth, any property damage beyond normal wear and tear, use of mechanical restraints, et cetera, as well as any internally substantiated violations of PREA. And then it also requires a quarterly report, kind of an aggregate report to the IG of grievances that youth have submitted to the facility and what the outcomes of those grievances were. There's also an amendment brought in LB 1085 and LR 298. 1085 adds inspection and reporting requirements to the Public Council for all DHHS facilities. And then the final, or LR 298, creates a special oversight committee of the legislature specific to YRTCs that has a sunset of this year. So they have to create a report and recommendations by December 15th of 2020. And presumably this is intended to interplay with the 5-year operations planning process. And I think I'll talk a little bit more about this in a second, but specifically the decision about whether to reopen the Geneva facility more fully or develop a different facility for girls in Hastings or otherwise. So then I'm going to skip to 1188, which is kind of the kind of a general but sort of schools focused and general evidence-based practices package. It requires that there be a designated superintendent position to oversee the educational programs at the YRTCs. And then incorporation of 1147, 1149, and 1150 require DHHS to use evidence-based and validated assessment tools to center evidence-based treatment programming. It prohibits the practice of limiting family contact as a sanction for behavior for youth who are at YRTC. It places responsibility for wear and tear, like kind of incidental stuff, with DHHS rather than the Department of Administrative Services, but keeps responsibility for major repairs, et cetera, with DAS. And then it includes language from an amendment on general file that Senator Brandt brought, who Geneva is in his district, which requires that as long as they exist, the named facilities of Kearney and Geneva should be gender specific, and that by July 2021, OJS has to ensure, quote, safe and appropriate gender separation. And so the cumulative effect of all of this is the legislature was pretty hung up about what Kearney becoming co-ed this year and whether girls were receiving equitable treatment there, et cetera. And so I think whatever comes of the strategic planning process that's going to occur over the next several months to a year, even though the girls have been at Kearney for nearly a year now, I think following the strategic planning, it seems really unlikely that Kearney would remain co-ed, and that rather we'll be going back to some form of gender segregated placements. So I've left 1148 package for last, and I'm sorry I'm talking so long compared to Judge Gendler. So I don't want to take up too much more time, but I think 1148 will probably most directly impact participants on this call because this is the court jurisdiction and oversight package. So I won't speak about, there's a number of bills that got amended into 1148 that don't have to do with YRTCs. So if you're interested in those, they relate to video depositions at CACs and that sort of thing. So if you're interested in that, maybe someone else will talk about it or I can answer questions later. But what LV 1148 at its base does is it says that court jurisdiction in the juvenile court is no longer going to be put on hold during a commitment. So there's going to be ongoing juvenile court jurisdiction. The relevant juvenile court for that youth has the opportunity to continue to hold hearings. In fact, there are required regular review hearings, an annual review backstop, as well as the ability for any party to bring a review, sort of an emergency review hearing to request the court to consider the youth's commitment and even to ask about early discharge, about whether it's appropriate for the youth to even remain committed. It requires OJS to provide monthly reports to the legal parties in the court. And there's a list of factors to be considered in the question of early discharge. If a party does move for that review hearing and ask for early discharge, the court can consider the extent to which a youth has completed the goals of the individualized treatment plan or received maximum benefit from institutional treatment, whether the youth would benefit from continued services under community supervision, whether the youth can function in a community setting with appropriate supports, and whether there's reason to believe that the youth will not commit further violations of the law and would comply with terms of intensive supervised probation. So the 1148 also requires at the outset, at the initial committing hearing on a motion for commitment to YRTC, that the court order designate a specific facility placement. So for any courts that have not been doing that thus far, the court order now needs to say, I commit this youth to YRTC Kearney or YRTC Geneva. And in exchange for this provision in the law, there was an amendment, a compromise amendment that OJS gets to be served with a copy of the motion for commitment and be a party for all matters related to the commitment, including the initial commitment hearing. So this allows OJS to provide evidence related to their ability to serve a particular youth, what facility, what their facility setup is to receive a youth into a commitment. And then if after a commitment hearing has occurred and a youth has been committed to a particular YRTC placement, whenever OJS desires to move a youth from that particular placement, say to another YRTC or somewhere else, they have to provide 7-day notice to all the parties and the court. And there's an opportunity for objection, just like any other placement change hearing under the Nebraska Child Welfare Statutes. So that gives anyone the opportunity to object to it and have a hearing on the question of, does my client really need to be at this new YRTC Lancaster, or can he be successful at Kearney, or for that matter, should he be discharged? It requires the youth's physical attendance at any of these hearings, but does permit the court to determine whether someone from YRTC has to be in person or not. And parents have a right to be notified of any hearings, but their attendance is not, they're not a necessary party. I think that's all. I'm happy to answer any questions about the YRTC legislation now or later. There's a fair amount of it, and obviously a significant amount of ongoing work being done to determine sort of what happens next in terms of the long-term vision for these facilities in Nebraska.
Thanks, Julia. We'll turn it over to Jeannie now. And just a reminder to attendees that you're muted, but you can write questions into the chat. And Tracy, we lost the slides.
Hi, good afternoon, everyone. Jeannie Bradner, and I am the Deputy Administrator overseeing Juvenile Services for the state. I have a few items to discuss today. The first is, which I believe it's on the bottom of the slides there, Legislative Bill 1064. That bill was introduced by Senator Breezy, and portions of Senator Crawford's bill LB 322 were also amended into this bill. This does extend the age for tobacco possession and use to 21 years of age. The other provisions that came from Senator Crawford's legislation have to do with sting operations. Those sting operations do allow persons who are 15 years of age but under 21 to assist a peace officer in determining compliance with these requirements. There is an exclusionary criteria for youth that are actively assigned to a diversion program or pending criminal proceeding, pending any type of activity under the juvenile code, or is currently on probation. So that was at the bottom there, the juvenile justice tobacco. The other ones are legislative resolutions, and I'm going to go to the middle two. LR 420 and 421 are the exact same language. One just comes out of the Health and Human Services Committee, and the other comes out of the Judiciary Committee. So these committees can jointly assess the issue at hand here. So these studies are looking at the racial and ethnic disproportionality in Nebraska's foster care and juvenile justice system. That would also include specifically those youth who are committed to youth rehabilitation and treatment facilities. There are a number of items that the resolution has called out in terms of an action plan for reducing disproportionality, maybe consideration of a need for a formal body to be able to lead the work and advise the legislature, the department, probation, juvenile services on any recommended policy or practice changes. Examining the data that currently is being captured and any limitations or inconsistencies with that data. And then what the need is for reporting from HHS and probation regarding race and ethnic makeup of youth that are being served. Racial disproportionality within the context of known risk factors. So again, we're talking about system involvement, poverty, and then protective factors such as the availability of resources that are currently in the community. Again, 420 is out of the Health and Human Services Committee. 421 is the exact same language out of the Judiciary Committee. The final legislative resolution that I have on my agenda today is 386. This is a resolution that was introduced by Senators Pansy and Brooks and Senators Vargas. And this resolution is looking at Nebraska law as it relates to filing and transferring cases involving youth between juvenile and criminal court. There has historically been some work on transfer cases over the years. I believe maybe in 2015-ish, there was some reform done there, but there is a continued desire to look at this population, who can be direct filed, who has to transfer up, transfer down, and what those provisions are. So we are excited to be able to examine, we've seen a reduction in the number of youth that are being charged in adult court, although there has been a little bit of an uptick lately. So that will be largely where do things sit today? What are best practice? What does the case progression data look like specifically to these youth who are pending transfer? Youth of color will be examined in relationship to this as well, and there are a number of other provisions there that I won't go into. Again, this one does come out of the Judiciary Committee. That's all I had. Thank you.
Thanks, Jeannie. We'll turn it over to Sarah now.
Okay, hi everyone. My name is Sarah Helvey, and I'm a staff attorney and the Child Welfare Director at Nebraska Appleseed. And just wanted to thank the Court Improvement Project for the opportunity to present today. I always enjoy this panel and chance to reflect on the legislative session. I'm going to cover a few child welfare bills and one interim study that we've been involved with this year. The first is LB 219. Yes, okay, just checking my chart here. LB 219, which was introduced by Senator Anna Wishart in response to a recommendation from the Strengthening Families Committee of the Nebraska Children's Commission and input from youth about barriers to obtaining their driver's license while in foster care. Across the board, a really low percentage of youth in foster care are able to get their driver's license, and that really impacts their ability to get to work and access education. Actually, I worked with some advocates in other states and in bigger cities and other states of public transportation. They're like, this is not our top priority, but here in a state like Nebraska, this is something that we heard a lot from young people. The bill was originally introduced in the 2019 session, so it was a carryover bill this year. And it did have several amendments since its original introduction. So I'll just mention the approved version, of course. It does a few things. It requires, as part of the transition planning process, that youth age 18 or older receive information, planning, and assistance to obtain a driver's license, including that the caseworker provide the child with a copy of the driver's manual, help identifying driver safety courses and resources to access those courses, and helping them identify potential means by which to access a motor vehicle for the purposes of taking a test to obtain their driver's license. It also requires, as part of the transition planning process, that youth age 14 or older are provided with all documents necessary to obtain a driver's license, such as birth certificate and social security card, when requested by the youth at age 14 or older, and again when the youth reaches 18 or ages out at 19 or 21. So those vital documents are already a requirement at 18, 19, or 21, but we were hearing from young people that they didn't have access to those necessary vital documents when they were seeking to obtain their learner's permit or driver's license. The bill also requires that youth in foster care shall not be required by virtue of their status as a child in foster care to meet any other requirements for driver's license under the DMV laws and any other child applying for the same license. And this is to clarify that youth don't need the foster parent to sign anything or give official permission in order for them to obtain a driver's license. That they should, as a best practice, get permission, but any other young person isn't required to do that. And so I'm wanting to just clarify that aspect for youth in care. Another bill, I should just mention, LB 977, originally introduced by Senator Kate Bowles, was amended also into LB 219 that related to the privatization in the Eastern Service Area. It requires a readiness assessment to be completed prior to the assumption of service provision for the lead agency in the Eastern Service Area, and requires the department to report to the legislature on that status. The combined bill was passed during, I think all the ones that I'm mentioning were passed in this late summer portion of the session and signed by the governor. The next one I wanted to mention is 848. Yeah, it's on there. It relates to the British Independence Program. This was originally introduced as LB 849 by Senator Patty Pansing-Brooks. This was also a recommendation from the Children's Commission, from the B2I Advisory Committee, and had a lot of input and advocacy from NICWIC, which is the Nebraska Indian Child Welfare Coalition, and the Nebraska headquartered tribes. It was later amended, as I mentioned, into LB 848, also introduced by Senator Patty Pansing-Brooks. That was a bill that was prioritized by the State Tribal Relations Committee to rename Columbus Day. It ended up being Columbus Day and Indigenous Persons Day. So the portion that's relevant to this webinar permits youth who age out of tribal court, so either youth whose cases originated in or were transferred to tribal court under ICWA, to enter the B2I program directly after they age out of tribal court. So the age of majority under most tribal codes is 18 instead of 19 under Nebraska law. So for most youth who age out of tribal foster care, there's a gap where the continuity of care is interrupted and they have to wait a year before they can enter into the B2I program when they turn 19. We were finding and hearing from the tribes that many of those youth become disconnected during that period of time. My understanding is that we really aren't aware of any youth who age out of tribal court that have been able to access the B2I program. And so that's the intention of this bill. It also still requires those young people to meet all the other eligibility requirements of the B2I program, including participating in a work or education activity. And then would you like me to mention 1061, or is Director Green going to do that? Okay, there it is. Great. So 1061 was introduced by Senator Crawford. That deals with the alternative response program and non-court involved cases, sometimes considered known as voluntary cases. Prior to the passage of this, there was nothing in state statute regarding those voluntary cases. And the AR program, which was originally undertaken as part of a federal demonstration project, was scheduled to sunset under the existing statute at the end of this calendar year. So LB 1061 does a few things. It eliminates that sunset provision indefinitely and provides legislative authorization for the continued use of AR. It establishes some statutory exclusionary criteria that were previously in regulation. There's a lot of them, so due to time, I'm not going to go through them all, but it's really clear there if you just click on the link for the bill. And of course, there's a lot of discussion among parties with regard to those exclusionary criteria. I think it may also authorize the department to create additional exclusionary criteria in the regs. I'll double check and put that in the comments. There are also statutorily required cases that must go to the red team, and those are also listed in statute, but I won't go through all of those due to time. The bill also defines key terms, including kin and relative caregiver, and not what a non-court involved case is, which again, as I said, was previously, even though we have quite a few of those cases, had nothing defined in statute. It articulates a statutory standard for when HHS has discretion to provide services without court involvement, and when immediate steps to protect the child and institute legal proceedings. So when there must be a court-involved case must be taken, and that's when the child is seriously endangered and the child's surroundings, and immediate removal is necessary for the protection of the child. It also clarifies the rights of parents and the legal authority of relative and kin caregivers when children are placed or are living temporarily in such settings in some of those non-court involved cases. It requires HHS to provide notice to parents in non-court involved cases of the reason for HHS's involvement, the possibility that a court case could be filed. It requires HHS to notify relatives and kin caregivers of their potential eligibility for public benefits and supports when they are caring for a child. And then, as I said, requires HHS to promulgate regulations regarding key aspects of AR and non-court involved cases. Also creates an advisory committee under the Children's Commission to provide additional oversight and stakeholder input ongoing on AR and non-court involved cases, which relevant to this group is required to include county attorneys, attorneys for parents, GALs, and families with experience in the system, among others. Senator Crawford designated this as her personal priority. It had the support of HHS as well as a range of advocates, and it passed, as I said, during this late summer portion of the session and was signed by the governor. I don't think this is on my list, but I wanted just to flag for folks LB 941. That was known as the Youth and Care Bill of Rights. It was introduced by Senator Megan Hunt. It didn't advance out of committee. It was indefinitely postponed, but I just want to mention it because I know that Senator Hunt is wanting to address some of the concerns raised during the hearing. This came out of an interim study that included focus groups with a number of young people about the input into the existing notice of rights that they receive and their interest in getting feedback about what recourse they might have if they feel those rights have been violated. And so hopefully that's one to watch for in the future. And then finally, one interim study I wanted to mention, that is LR 422. That was introduced by Senator John Arch of the Health and Human Services Committee. That's to examine changes to child welfare policies and practice during the COVID pandemic and the practices that may have been adjusted to in the interest of maintaining the physical safety of workers, children, families, and other stakeholders. That includes the type of services that have been happening during this period of time through virtual means, the cost of telehealth services, the ability to protect child and family privacy through the use of that technology, and then also checking in on progress toward permanency and how we're providing for that child and caregiver bonding during that pandemic. So that's one that's obviously very relevant to the present moment and gives us the ability to make any adjustments that may be needed. So I think that covers my section. Hope I didn't take too much time, and I'll pass it on to the next person, which I think is Director Green.
Thanks, Sarah. Yes, we'll turn it over to you, Steve.
Hi. Good afternoon, everybody. My name is Steve Green. I'm Deputy Director of Policy and Legislative Services at the Division of Children and Family Services. And thank you for the opportunity to once again share or highlight some of the bills and LRs that have had an impact on our department and division. Not wanting to be too redundant, I'm just going to offer from sort of the CFS perspective of what implementation for some of these things will look like, because there is overlap with some of the presenters before me on a few of these bills. So I will try to be brief in presenting. So the first one that I see is LR 410. It's a legislative resolution regarding an update with sort of where we're at with St. Francis Ministries in the Eastern Service Area, which is the Omaha metropolitan area. Each year we get CFS and DHHS gets quite a few LRs that impact our department and our division. This will be one, obviously, that we'll be participating in with St. Francis, sort of similar to the LR that we had. I guess it wasn't an LR, but it was a special update to the HHS committee regarding the transition that was occurring in October between Promise Ship and St. Francis. And this year specifically will be an update, metrics, those types of data that we'll share with the committee on sort of how the transition has been in the current state of the ESA in light of St. Francis Ministries providing case management services. The other one is Sarah had mentioned is LR 422, which is modifications that we made during the COVID impact. Obviously, COVID is still happening. It has not gone away, and so we still are sort of living in the shadow of the new normal with child welfare. Just a couple observations related to that. As you all are probably aware, we did see a decrease in the amount of reports coming into the hotline, specifically tied to schools being going to virtual sort of at the end of last semester or last school year. As schools have sort of come back into session, we have seen sort of a rise or return back to, I wouldn't say normal levels of reports into the hotline, but we are seeing that those reports specifically with educators on the rise again. So in some ways that's reassuring for us that at least we know that there are multiple eyes now on some children, and that's an area that we continue to monitor. Obviously, so much of the work that we do in child welfare is face-to-face, and so making such a shift in such a quick amount of time did require some policy changes, and so we actually look forward to that discussion with the committee, and also continued dialogue with our child welfare stakeholders and partners there. So that's LR 422. One that I wanted to talk about, and I'm not sure, I don't see it on there, but it's important for us, is LB 1148. It was originally a bill that was introduced by Senator Geist. I think it was 975 that was eventually amended into 1148, which contained a amendment to our sort of our CAPTA language. So there was a federal change in the CAPTA law regarding I'm forgetting the word now that I'm looking for. It's failing me. Yeah, sorry, I can't remember it. Immunity. Thank you for the person that provided that. Immunity for good faith reports for medical evaluations, or civil immunity. And so we needed to get a change in order to maintain our CAPTA funding, which I think is around $500,000 per year. It's used for prevention. We were able to get that through NLB 1148, and the Governor Ricketts just signed a required CAPTA assurance letter that we just submitted. So that was an important sort of bill that we had to get across the finish line so that we could secure and maintain our federal funding related to CAPTA funds. As Sarah talked about, LB 1061 with alternative response, that was a significant bill for us. Because we really do believe alternative response has been a great sort of prevention program and specifically engaging families and family engagement. The other part of it was, I think what Sarah highlighted was just the ability of a lot of cross partners working together to get that bill across the finish line. And, there was a lot of meetings with Senator Crawford and Howard, just sort of working through the bill to get it to a place that we all could support. And so I think for us as CFS and DHHS, we're just really proud of that bill, even though, and because it involves so many different systems, partners and conversations. So that has been a good experience or great experience for us. For us right now, it's really going through the implementation part of 1061 for us as a program. First, developing, there's two different areas that we're developing rules and regs or promulgating rules and regs that always take some time, but specifically related to initial assessments. And then also the process involving non-court involved cases, the right of any child, parent, caregiver, or relative caregiver to administrate an appeal of any department action or an action of non-court involved. So those are going to be some hefty reg rules and promulgation. Of course, we want to and we will engage you all and those child welfare stakeholders and providers as we're developing this. I know part of it is there's an ongoing attendance on our part for the AR committee, and so we're going to be as engaged on that as possible. The last one is LB 848, which Sarah also mentioned, which is the bill related to B2I. I think she did a great job articulating the major changes. For us, it's really is providing that service gap for tribal youth that are being now eligible when they reach age of majority that was just not there prior to this bill being changed. So that's in essence what we have. Thank you again for the opportunity. I appreciate it and look forward to any questions that you all might have.
Thanks so much.
My turn. This is Mary Pat. I'm from CIP. The first bill I'm going to talk about, I'm going to go down to the LBs first, is 582 by Senator Tom Brewer. This bill basically expanded the current law, which required a person to have actual knowledge or belief that a gun was stolen in order to be convicted. The new section now makes it possible to obtain a conviction if the person who obtains the stolen firearm should have known or had reasonable cause to believe that the gun was stolen. And the new section is also a Class 2A felony. So we might see an uptick in juvenile court in gun charges. The other LB is 751 by Senator Blood. As you know, in current law, a school may refer a case related to excessive school absences to the county attorney to pursue truancy in juvenile court. The school may not refer until the student has been absent for more than 20 days and a collaborative plan has not been successful to resolve those barriers to attendance. The collaborative plan is developed by the school, the child, and the person with legal or actual charge of the kiddo. And they're required to consider certain factors in that plan. LB 751 amended Section 79209 to add mental health to that list of recognized barriers to attendance when that plan is created between the school and the parents and the kiddo. So this may impact some truancy cases coming over. At the very least, it certainly is going to help kiddos who are struggling to attend school if they have some mental health issues. So hopefully they'll get some helps in place for them. The next, the LRs I'm going to cover are 387 out of Health and Human Services Committee. The purpose of this LR is basically to examine the processes by which children of 0 to 3 who are victims of abuse or neglect, and are they able to access services through Nebraska's Early Development Network. The study is going to look at the percentage of kiddos from 0 to 3 who are victims of abuse and neglect that receive services through Nebraska's EDN network. The study is going to look at barriers to the process of providing the services. It's going to include info from various EDN's leadership, families, and other interested parties. Eligibility is going to be looked at, and then obviously potential solutions for any issues that arise. There's no hearing listed yet for this LR. The next one is LR 405 by Senator Kavanaugh out of Judiciary. Basically, the purpose of this is to examine the feasibility of developing a Nebraska Juvenile Justice Information System. Basically, a warehouse of juvenile justice and child welfare data. The long-range purpose would be obviously to prevent youth involvement in both systems. Currently, as you know, everybody knows, juvenile justice, child welfare, education, and law enforcement data are maintained by all the separate agencies, making research efforts to improve, very limited. And it also lacks uniform definition and independent evaluation. So this study is going to look at gaps in that. They're going to look at the legal issues involved, concerns and solutions of the agencies that I discussed earlier, any MOUs that might be needed between local and state agencies, obviously processes for matching these youth cases across systems will have to be addressed, and the process for releasing the data for research and evaluation purposes. And there's no hearing listed on the site yet for that LR as well. And that ends my part, and I'll shoot it over to Mary Ann.
Thanks, Mary Pat. And thanks to all the presenters. This has been really interesting. So a few bills I wanted to talk about. First, LB 924, which was a Senator Chambers bill, which requires law enforcement entities to receive anti-bias and implicit bias training and testing designed to minimize apparent or actual racial profiling. And the provision of this training is related to grants, funds, loans, other funding for those departments. So it is a requirement. And that was signed by the governor. The next bill I just wanted to mention was LB 1036. This was a Senator Moorfield bill that was amended into LB 1004. It would have allowed young adults who are 18 or over to make healthcare decisions for themselves, and also people under the age of 19 who are committed to corrections to consent to medical and mental health services. This bill was vetoed by the governor, so it passed the legislature and was vetoed, and it was one of those bills that was vetoed past the end of session, so the legislature did not have a chance to override the veto. And I do think that it is related to that interim study that Judge Gendler mentioned that's looking at some of the ages in juvenile court. And then I just wanted to mention LB 1180 or LB 1148 one last time. I think this is the third time it's come up. And I wanted to mention the part about video recordings of forensic interviews. So there's language in the bill that clarifies that the CACs shall maintain those video recordings of forensic interviews and that they shall not be released except in very specific situations. And that includes if they need it to have peer review for accreditation purposes for the CAC. It can be released to law enforcement agencies or agencies who prosecute for their investigation and their prosecution. It can be released to the Office of Inspector General of Child Welfare. Secure access can be provided for DHHS to view the video. And it can also be released under a court order for specific purposes, and that includes for the defendant to review and also to hire experts that they may want to have testify, and also for in-camera testimony of a young person. And then a couple of interim studies I wanted to mention. The first is LR 382, and that is from the Legislative Performance Audit Committee, and it's been assigned to the HHS committee to look at. And its purpose is to study the oversight of non-court involved child welfare cases. So what that study will be looking into is what oversight entities currently exist for non-court cases, who has authority and access to the information regarding these cases, what are the differences in oversight across the state of these cases, and whether the current oversight is sufficient. And it specifically mentions that the committee shall solicit information from DHHS and all the service areas, the Foster Care Review Office, the Child Abuse, Neglect, and Investigation teams, and then other interested parties. And then LR 399 is a Senator Groney study that is assigned to the Education Committee. And the purpose of this one is to conduct an in-depth review of how at-risk and economically disadvantaged students are identified as a qualification factor for state-funded education-related programs. And so what this is really looking at is the use of the school lunch applications for free and reduced meals. Those are often used as a proxy for determining poverty levels for schools and participation in a lot of the different programs at schools. So it's going to look at the use of those school lunch applications as a proxy, how community eligibility and direct cert have had an impact on eligibility for state programs. And those are programs that allow all kids at schools to eat for free and not use the applications. How poverty is identified in other states, best practices for determinations of poverty, and if there are statutory updates that need to be made. And then the last LR I'll mention is LR 413, which is from Senator Howard and has been assigned to the HHS committee. And this is an LR to continue oversight of the residential facilities for juveniles, including the YRTCs, under the supervision of DHHS. So just an additional oversight piece over YRTCs, but also other residential facilities. And one other thing I wanted to mention is that bills that were signed into law will go into effect November 14th, unless otherwise specified, or there was an emergency clause, which a few of the bills mentioned did have, and that's notated in the chart. And then I do know that the B2I provision, expanding that to tribal youth, that does not go into effect until July of 2021. And so now I think we'll open it up for questions. I know that there were a couple that were in the chat. One was, how is LR 409 similar or different than Senator Slama's LR on drug testing last year? And I do not know the answer to that, so if anyone on the panel wants to jump in.
This is Steve. I took a brief look at both of them. It looks like, and I didn't crosswalk it before this, but there is a little bit of a difference, but it looks like the majority of them are word for word, similar to Senator Slama's LR from last year. There's a couple, I think, changes related to some of the initial assessment, but other than that, it seems to be a pretty sort of similar LR with not any major noticeable changes.
Thank you, Steve. And Juliet has answered this question pretty extensively in the chat, but I'll still read it out. Is there any information regarding how the YRTCs will house transgender youth? And I don't know, Juliet, if you want to just provide a quick summary of what you wrote in the chat.
Yeah, so I basically wrote in the chat that unfortunately none of the legislation specifically contemplates trans youth or gender questioning youth even. So I guess what I did say was that I think that there is an opening with LB 1148 by providing some more specifics related to determining the right initial facility placement during a commitment hearing, as well as the opportunity to have ongoing review hearings to consider whether commitment remains appropriate. That there's an opportunity there for GALs or for defense attorneys to raise that question or concern as they relate to your individual client. about whether the facility the court is contemplating committing to is an appropriate facility for your client. Given that there's a whole lot in there now about the facilities being gender segregated by gender and not really any reference to a broader gender spectrum or how that interplays. And I did have to add that I think that's a problem for nearly all congregate care placements. So of course, as we're advocating for youth who are before the juvenile court, that is among a number of considerations I think that should be taken into account as you're thinking about, trying to work even a little bit harder for an individualized in-home plan or, supportive foster care placement rather than a congregate care placement more generally.
Thanks so much, Juliet. And I see we have a question for Sarah, but Sarah may have jumped off the webinar. And it was in regards to the independent living plan for youth in foster care. Does that apply to youth in foster care for whom probation has placement and care responsibility, or any of the other normalcy protections for youth?
This is Jeannie. I can jump in there. This is something that gets contemplated each year in terms of youth rights. And it is a fine line because youth under probation supervision, their parents still have parental rights intact, and obviously youth have their own independent rights that any child would have. And so it is a different scenario than when youth in the abuse neglect system, the state is acting as their parent and or guardian. And so not all of the provisions do apply. We obviously want to ensure youth are treated in a as normal as possible manner when they are in placement facilities, but recognize the fact that sometimes those are community protection issues. And so it is a little bit separate and distinct for the probation population.
Thanks so much, Jeannie. I do think that's all the questions that we've received in the chat. So I think we can probably wrap it up at this point, unless there was anything else that we missed. Okay, well, thank you everyone for joining us today. I don't know, Deb, if there was anything else you wanted to say at the end.
No, just thanks everybody for the presentation. I think that you covered a lot of legislation that is really relevant to the work that we're doing in the juvenile courts. So thank you. And for those of you who are attorneys, you can see the CLE credit activity number on your screen. And just a reminder about the CIP conference, September 28th, and the webinar on Medicaid expansion on the 22nd. So again, this webinar will be recorded and placed on the CIP YouTube channel if you want to reference it. And I think that's everything for today. Thank you so much.